Okay, if our services in the rear of chambers are ready at this point, we'll go ahead and call the meeting to order. I'm not sure what that hand signal means. Maybe it's go ahead, it's all good. Okay, thank you so much. We are back today for the board work group meeting. And we're convening at 10:08 a.m. And we'd like to ask Ms. Cicchetti to please call the roll.
Good morning. This is Ms. Taylor, Chief of Board Proceedings, acting as clerk today. We'll start by recognizing Member Schaefer. Member Schaefer, if a member of the board attends the meeting by teleconference from a remote location, the member shall disclose whether any other individual, 18 years or older, is present in the room.
Do I just talk? Or do I have to do something with the mask? Hi, I have Dr. Cody Pedersen, my chief of staff, with me. He's the only other person. He's of age, and we all know him.
Thank you very much. At this time, I'll call the roll. Chair Lieber.
Here.
Vice Chair Gaines.
Here.
Member Vasquez.
Present.
Member Schaefer.
Here?
And Deputy Controller Emron.
Present.
A quorum is present. Our first order of business is our safety and informational announcements. Welcome to the May Lee Office Complex. First, I would like to remind audiences to silence their cell phones and other wireless devices. Our safety announcement. In the auditorium, the exits are located on each side of the stage at the front, with additional exits at the rear. Please take a moment to locate the exit sign and the nearest exit in the event of an emergency. This board meeting will be live streamed to the public and posted on the BOE website. Public comments are taken on agenda items. If there are any members of the public wishing to speak before the board on any of the agenda items in person, we ask that you complete and submit the Sergeant at Arms a public comment appearance sheet located at the entrance of the auditorium. If you wish to speak before the board by telephone, please dial the phone number and access code provided on our public agenda notice and follow the instructions of the AT&T moderator. When giving public comments, please limit your remarks to 3 minutes. We also ask all speakers in the auditorium or on the AT&T phone line to state their names before speaking for the record. This concludes the safety and informational announcements. Thank you.
Thank you, Ms. Taylor. And I'd like to turn over the proceedings to Mr. Emron, Deputy Controller.
Thank you so much, Madam Chair, and good morning to you all, and welcome to the California State Board of Equalization Board Work Group here. It's a very historic and exciting day at the State Board. So my name is Hasib Emron. I'm the California Deputy State Controller. I'm honored to chair today's proceeding on behalf of our great State Controller, Malia Cohen. Controller Cohen established this work group because she believes and has directed this office to act on that belief that California's property tax system deserves guidance that is current, consistent, and fairly applied in every county in this state. To the members of the board, your participation brings the full authority and responsibility of the Board of Equalization to this process. I want to thank you all. To our county assessors, county councils, practitioners, and taxpayer representatives, you are the reason this work group can produce something meaningful. The knowledge in this room accumulated through years of appraisals, hearing, and litigation is exactly what updated guidance requires. We are grateful for your time and your commitment to this process. This work group has clear origin. At the board's August 2024 TRA hearing, Taxpayer Bill of Rights, the board received several hours of testimony from taxpayers and taxpayer organizations raising serious concerns about inconsistencies on how intangibles are identified, valued, and excluded. Those concerns were not abstract. They reflected real disputes, real litigation costs, and real uncertainty about whether California's property tax system was being applied uniformly. Controller Cohen heard that testimony and acted upon it in October 2025. We went ahead and formally proposed to establish this work group, tasked with exploring methodologies and developing recommendations to address those concerns. The board approved that proposal, and today is the result of that. This work group central task is clear. Assessor Handbook Section 502, Chapter 6, the board's primary guidance on the treatment of intangible assets and rights has not been updated since December 1998. In the nearly 3 decades since, 30 plus years, the California Supreme Court and the Court of Appeals have issued a significant body of decisions that have shaped, clarified, and in some areas substantially changed how assessors are required to approach these questions. The handbook that assessors consult as their primary reference and that courts themselves have cited as authoritative guidance no longer reflects the law as it stands today. The consequences is inconsistency. Without current uniform guidance, county assessors exercise judgment differently. Taxpayers with comparable properties in different jurisdictions may encounter methodology and different outcomes. Assessment appeals boards adjudicate disputes without a reliable common framework. That inconsistency is contrary to the board's constitutional mandate to ensure that assessment practices are uniformly and fairly applied throughout the state. This work group purpose is to address that gap systematically, to examine current methodologies, hear from the full range of stakeholders, and develop recommendations that will allow the board to issue updated guidance reflecting where California law actually stands. And this moment matters. The urgency of this work group is underscored by the California Supreme Court case, August 2025 decision, Olympic and Georgia Partners LLC versus County of Los Angeles. It was a 4-3 majority. And then the scope, structure, and what we're asking for, the work group's mandate is to develop recommendations to the board on methods of valuing intangible assets and rights. Those recommendations should address the legal standards that govern the exclusion of intangible value from taxable assessments, the methodologies assessors should apply to identify and quantify that value, and the evidence standards that govern disputes about enterprise assets. The goal is guidance that assessors can apply with confidence and that taxpayers and practitioners can rely on for predictability. Today's agenda is designed to build a complete record from 3 distinct perspectives: the legal and historical development of the doctrine, the operational realities facing county assessors, and the experience of taxpayers and private practitioners. Each perspective is essential. The recommendation of this work group produces what will be only as sound as what we record here today on record. So on behalf of the controller, I ask every participant to engage fully and candidly. This is a formal process, and the controller and myself intend to treat it as one. Our office will prepare and circulate the minutes of today's session, and I encourage everyone in your oral presentation, get as much onto the record as you can, and then also we'll allow time for written submission afterwards as well. So I'm really looking forward to this, and the final recommendations will be presented to the board in a timely manner. The controller and I are both confident that the expertise assembled here today is more than equal to the task. So on behalf of our great state controller, I will invite each board member to offer opening remarks, and we will proceed directly into agenda item 2. Thank you.
Thank you, Mr. Emron. I'll go ahead and go first with my opening comments. And I wanted to thank Controller Cohen and her staff, and particularly Mr. Emron and many others in the leadership of her staff for bringing forward these very important issues for the board's attention. This hearing has really been a long time coming. It's been under discussion by the board. And I particularly look forward to presentations on intangibles by our board staff, presentations by members and leadership of our membership organizations, which are very active in policy in California, as well as our assessors, and presentations by other practitioners and by members of the public. As administrators of California's property tax system, it is critical that assessors, the public, stakeholders, and practitioners all receive clarity in the treatment of intangibles. Recent court cases have added complexity regarding the treatment of intangibles, and for decades there's been robust discussion that may be on the treatment of intangibles that may be found in personal property. Examples of non-taxable intangible property include notes, corporate securities, shares of capital stock, solvent credits, bonds, deeds of trust, mortgages, liquor licenses, insurance policy, club memberships, and copyrights. So this is a very complex area of property tax administration that demands that we give our attention to it. And with that context in mind and our desire to see that there is clear guidance going forward, I very much look forward to this work group. I know that today is just the beginning of the process, for us, but I so much appreciate everyone who has traveled here to give comment, and as the Deputy Controller remarked, also providing written comments after this hearing. Thank you so much.
Thank you so much, Chair Lieber. Vice Chair Ted Gaines.
Yeah, thank you very much for what I think is very important hearing and the lack of clarity in terms of intangibles. And I remember when we were hearing some of the facts on the Olympic and Georgia Partners LLC versus County of LA, and the intangible aspect of the naming of a hotel, and then the Supreme Court really providing a split decision, which again shows that we need more clarity. So if we can provide the clarity and figure out how to land on that as a board, and then have that clarified maybe through an LTA or whatever the right pathway is to provide guidance in the future, I think that would be very helpful, and look forward to hearing more about intangibles. Thank you.
Thank you so much, Vice Chair Gaines. Member Vasquez.
Thank you, and thank you to the Controller's Office and to Deputy Controller Imran for putting this thing together. Appreciate it. I know it's been tough to try to put all the pieces together. And not to repeat several, you already stated some of the cases and some of the importances, and the fact, I think you mentioned, which is, I think, a key thing, the assessor handbook, that it's so outdated. And the one thing that I guess kind of jumps out is, since there's been several cases over the years that I think impact the intangible assets, the rights, and are crucial that we should vet these and as we move forward to make sure that we're providing the right guidance and incorporating some of these most recent cases as we move forward. And I also just want to thank especially all the speakers and the stakeholders that are here today that'll be coming before us. I understand most of them are in person for traveling and making the time to come out and share their thoughts and ideas, so we hopefully get it right as we move forward. And appreciate and looking forward to hearing feedback, especially those that are on the ground implementing these rules. Thank you.
Absolutely. Thank you so much, Mr. Vasquez. Mr. Schaefer, if you can hear us, do you have some opening remarks?
Thank you. Yes, I do. I've always considered all the various aspects that you refer to as intangibles as summed up as goodwill. But I see now goodwill is really half a dozen different names. We do have an obligation to increase the tax revenue to help pay for our highways, hospitals, schools, etc. But it's also very important that we consider to be business friendly. We have a lot of businesses leaving the state, and we have a reputation as being one of the most unfriendly business atmospheres in the United States. So I would just want to be sure that the things that we go after, like locations and zonings, that we have a good reason to find that there's a taxable value there. I'm all for fair taxation, but I also don't want to upset any of our business interests because they're having enough trouble surviving as it is. Thank you.
Thank you so much, Member Schaefer. So with that, I want to thank the board members for their remarks. Let's move right on to agenda item number 2. Madam Secretary.
Agenda item number 2, history and legal development of intangibles assessment in California. Presentation of a comprehensive overview of the historical development of California law relating to the identification, valuation, and assessment of non-taxable intangible assets and rights. Our speakers today, David Young, Property Tax Deputy Director, State Board of Equalization, and Richard Moon, Chief Counsel, State Board of Equalization.
Wonderful. Thank you so much, gentlemen. Appreciate your time today. We can go ahead and kick this off. Madam Secretary, can I ask if there are going to be some slides? Can we play it on this back projector here? Yes, please. And Mr. Young, Mr. Moon, appreciate it, and you guys can go ahead and get started.
Of course. Of course. Thank you very much. For the record, my name is David Young, and I'm the Deputy Director of the Property Tax Department here at the board. Mr. Moon, you want to introduce?
Richard Moon, Chief Counsel of the Board.
Yes, thank you. Thank you again for this opportunity to present before the board. I also want to echo your gratitude to all the speakers, all the stakeholders that are here today. I look behind me and I see just a wealth of knowledge and experience behind me. So I just wanted to say thank you for that. So my goal here today is very, very simple. And to be very, very frank with you, it won't be the easiest part of your day. All I want to do is give you a little bit of framework and a little bit of background in which to hear and to receive the testimony that's going to come after us. So what I'm going to do is I'm going to go over a little bit of the history and the legal framework and give you a brief overview of where we stand today with our guidance on intangibles. So with that, I'll go ahead and start. So the legal framework for intangibles. Next page, please. Thank you. If you can, okay. Not, next slide. Oh, perfect, thank you. So the legal framework basically stems from our Constitution, the California Constitution. Article 13, Section 1 provides that all property is taxable unless specifically exempted by law. We're going to touch on Article 13, Section 2, but I'm going to save that just for a little bit later. If you can also hit the next slide. Thank you, Mary. The modern history of property taxation of intangibles actually truly begins right at 1933. So prior to that, with that Article 13, Section 1, all property is taxable. It included intangibles. In 1933, the Constitution was amended to add what is now Article 13, Section 2. That section provides that only certain types of intangibles are taxable. Those are notes, indentures, shares of capital stock, bonds, solvent credits, deeds of trust, mortgages, and any legal or equitable interest therein. So they basically said these types of intangibles are taxable. So what that actually did, in essence, was basically made everything else that is not named non-taxable. So that was 1933. The next, things were relatively quiet for a little bit, and then the next case that of note was in 1948, and that is Rome versus the County of Orange. The facts are that the courts taxed a liquor license in its assessment of real property. The 1933 amendment allowing taxation for certain types of intangibles effectively exempted all other types of intangible property. That meant that the county could not directly tax that liquor license. However, the court did include an important clarification that intangibles that cannot be separately taxed may be reflected in the value of that taxable property. So you can basically assume its presence.
Can you clarify that?
Yes. So in that instance where they said a piece of commercial property, it's being run as a liquor store. The license itself has a value. You can buy it, you can apply it, and you can sell it. That cannot be included in the value of the store. Let's just say the store is worth $500,000, and you can actually attribute a value to that liquor license. You have to take it out of that if you can show that when you appraised that store, it included that liquor license. If you can identify it and it's in there, you have to take it out.
Okay.
So, and the other instance is that you cannot say that, hey, this countertop, all the amenities in there, the property in there, it can be used as a liquor store. It's just that you can't include it. You can't include the value of that license.
Okay, thank you.
Okay, of course. So, so I think we just got jumped ahead and covered the next one. But if Mary, if you can skip to the next one after that. Okay, so there were a couple other court cases that happened after 48. The next one was Michael Todd. Michael Todd, at issue was the value of the negatives of a film. Basically, it's Around the World in 80 Days. The courts held that the copyright cannot be directly taxed, but the market value, which is the value of the property put to its beneficial or productive use of the negatives, could be enhanced by the presence of the copyright. It is not merely the salvage value or the scrap value of that film. So it can be, at that point, valued as the actual film itself. There is later on development in the taxation of films, but that's a little bit, they did enact a law that changed that later on, but that's what Michael Todd found. And then the next case I wanted to highlight was GTE Sprint, and that's in 94. So we're going down quite a few. There were many cases in between, but I'm only highlighting the ones that I think are truly illustrative. GTE Sprint involved certain enterprise-related intangibles, such as the trade name, the customer base, an assembled workforce, and favorable leases and goodwill. The value of intangible assets is not always only the enhancement to the tangible property. Thus, the board had to consider evidence of intangible value of these enterprise-related intangibles when presented with it. So what that basically said was that when there is evidence of intangibles, not everything is merely, you can't just assume it all went to enhance the value of the taxable tangible property. You have to consider what the intangibles are and how they contributed or added. Are they embedded in the value of the taxable property? And I will mind you that the GTE case was actually of status SC at that point. And they still are.
Could I ask another
Sure.
clarification question? Because on this GTE, you're talking about trade name, customer base, and then you mentioned goodwill. Would a trade name be considered goodwill? And a customer base? I'm just trying to get clarification on what is goodwill?
Goodwill tends to be a much broader category and it may subsume some of that, but usually a trade name is something that's identifiable. Like Nike, everybody knows that brand name and there's certain value to being associated with Nike. If I marketed a shoe as Dave Young's shoe versus a Nike, there is real value to being attached to that name. And customer base is basically who basically subscribes to your services, and that is an intangible that should be considered.
Would that be considered goodwill?
Yeah.
Would a list of customers could be considered goodwill?
It could be.
Okay.
It could be.
Trade name
Yeah.
could or could not be?
Mr. Boone, is there
Yeah, well, I think you've identified one of the issues that come up in the consideration of intangibles, and that's identifying whether a particular intangible is discrete on its own, or is it subsumed by a different type of identified intangible, or can you even identify this particular intangible, and what does it all consist of? What, for example, contractually shows that it's there, or what about the business or the income stream or the property demonstrates that it's there and that it's part of the property or it's part of the business. So I think this is all part of the difficulty.
Okay.
Yeah.
Copyright has value,
Yes.
right? I don't know in terms of whether that's defined as an intangible or not, but I'm just thinking of Disney, right? Didn't they have a 100-year copyright that just expired?
On,
Something like that.
yeah.
Yeah, so.
So now anybody can use those Disney characters.
Right, so I'm not sure about the Disney particular example, but a copyright is certainly an intangible. I don't think there would be any doubt about the fact that it's an intangible. The issue with property taxation is the fact that you cannot tax that copyright directly, but you can assume its presence in tangible property.
Okay.
So the Michael Todd case that Mr. Young referred to is a good example of this. So there was a film negative that had a copyright attached to it, the right to reproduce that film. And so the copyright by itself had some value, but the assessor could not tax that directly. But they could ascribe a value to the negatives that include the right to make reproductions of those negatives.
Okay.
So that's the distinction.
Yes,
And
okay.
I think that's sort of, even for 100 years, that's sort of, what's been argued about.
Yeah, it's more valuable than the film itself, than just,
Yeah.
Well, the film with the right to it is
Yes.
more valuable than the film without the right to it.
right. Okay, very good, thank you.
Okay. Thank you, Mr. Moon. So now we jump to 1995. With those couple court cases, there were some legislative changes. Chief amongst those was basically the amending of Revenue Taxation Code 110. So there were a couple of provisions added. Revenue Taxation Code 110 provides the directive to remove the value of non-taxable intangible assets or rights. So that became basically in law. 110E further provides that, however, despite 110D's directive, taxable property may be assessed and valued by assuming the presence of intangible rights, assets or rights necessary to put the taxable property to beneficial or productive use. Additionally, it also amended Revenue Taxation Code 212C. It added 212C. It's pretty similar. It states that intangible assets and rights are exempt from taxation and except as otherwise provided in the following sentence, the value of the intangible assets and rights shall not enhance or be reflected in the value of taxable property. The next sentence reads, taxable property may be assessed and valued by assuming the presence of intangible assets or rights necessary to put the taxable property to beneficial or productive use. So basically it's embedded in two portions, in 110 and 212. So with that change in law and clarification in law, the board started a project to update our guidance on it, and that is that started, I believe, in the end of 95, beginning of 96. The original manual was a 1988 guidance, and it was titled The Income Approach to Value. It focused heavily on standard real estate math and offered minimal and often ambiguous guidance on how to extract complex business intangibles. So there was a pretty comprehensive rewrite. 1998, we started a interested parties process in which we got stakeholders, assessors, practitioners, the public, to basically weigh in on the intangibles. We were able to get to a certain point, and the board adopted that addition on December 10th, 1998. The part that was added, it was a pretty much a very comprehensive rewrite of the whole assessor's handbook. What we did do was we added chapter 6. And chapter 6 dealt with the treatment of intangible assets and rights. The chapter was considered a milestone, and it was basically drafted through an open, contested process involving heavy debate amongst the county assessors and industry groups. At the time, the assessors, the CAA, actually produced and wrote their own guidelines that varied from ours. So what is actually covered in chapter 6 of our handbook? Basically, it describes how to isolate and to exclude intangible properties. And it establishes that while the appraisal can assume the presence of a permit or license to value the physical structure at its productive capacity and but it cannot capture the standalone cash value of that intangible assets. So what we basically did was we laid out the very, very fundamental groundworks of how to treat intangibles. And those steps are basically, first, you got to know what an intangible is. We identify some of them. Then you got to basically see if they're embedded in the value of the property that you're appraising. If they are, how to value it and to remove it. So that's the basic guidance. Now comes the hard part. We have given you basically the skeletal framework in which to basically analyze this. We're looking at now 98 to 2026, going on 30 years, not quite, 28 years. Has there been enough development in either court cases, guidance, changes in industry? How do we augment what we're given as advice? How do we go ahead and add a little more clarity and uniformity? So there are 2 court cases that I think are fairly illustrative. The first one is a court case in 2013, and that's the Elk Hill Powers LLC versus the Board of Equalization. Once again, our state assessee. So the facts are to build and run a 500 megawatt power plant, Elk Hills had to buy roughly about $11 million worth of emission reduction credits, ERCs, that essentially intangible pollution permits required by the local air districts. So in order for them to run it, they had to buy basically these credits in order to run it. So in the cost approach, the board added the replacement cost of these ERCs directly to the assessment, arguing that because the plant could not legally operate without them, they simply assumed the presence under section 110E. So they assumed its presence. The board appraisers made no deduction from the net income for the ERCs. So we basically appraised it with 2 approaches to value, the cost approach, in which we added that value, and then in the income approach, where we did not remove an increment from the taxable income. What the court holdings were. So Supreme Court holdings, ERCs, are quantifiable, independent, intangible rights that may not be directly taxed. The court stated that assuming the presence of an intangible does not permit the appraiser to add the independent value to the tax roll. So the findings. The asset can make the real estate useful, but the distinct value may not be added to the cost approach. So they found that it had a distinct value, you can't add it in the cost approach. They also found that in the income approach, the court agreed with the board that no deduction for the ERC was necessary since Elk Hills had not shown that the ERC had a separate income stream attributable to it. So they said, hey, you did not show that it was embedded in the income stream, therefore you didn't have to remove it. So what follows is a lot more litigation, including several hotels, in which the board actually filed an amicus brief on one of them. But the hotel cases, basically, the one I wanted to highlight was the most recent one. It's the Olympic and Georgia Partners LLC versus the County of Los Angeles, and that's a 2025 court case. Most recently, the Supreme Court weighed in on intangibles issued again in one of those hotel cases, Olympic and Georgia Partners versus LA. The facts. The dispute involved the valuation of luxury JW Marriott and Ritz-Carlton Hotel complex at LA Live. Taxpayers argued that two unique revenue streams should be deducted from the taxable income streams as exempt intangibles. Those two streams are a multi-million-dollar transient occupancy tax, city subsidy paid to incentivize the project's construction in the form of a rebate. So the city collected these occupancy tax and actually rebated it back to the property. And a $36 million key money paid by Marriott to the owners to just secure the lucrative right to manage and to brand the hotel as one of theirs.
Excuse me.
Yes.
So this one was LA Live you mentioned. So at the end of the day, what was the ruling on the intangibles on that one?
I think in one more slide after this,
You got it.
we're gonna get to it. Okay. And additionally, the owners challenged the county's valuation of its enterprise assets. Those are the flag and franchise, food and beverage operations, the workforce in place. The county did not dispute that assets were intangibles and that their values to Olympic must be removed. It relied on what is called the Rushmore method, an appraisal methodology in which deducting the standard management fee to remove the value of those hotel enterprise assets. So there were a couple of things. They challenged whether the rebate of the occupancy tax was a valid part of the income and whether the key money was also part. And then they also challenged whether that method of valuing, the income method, was accurate. Just removing the franchise fee, or did that remove all of the value of the intangibles?
So is a TOT tax considered moving forward? Or is that a separate issue?
No, those are the three main issues at heart.
The three.
The tax, the key money, and the method in which they used to value it under the income approach. Did it remove enough of the tangible assets and rights? So the Supreme Court's holdings, here we are, we're gonna get to them. The Supreme Court's issued basically a split decision. The counties won on the revenue streams. The courts held that both the tax rebate and the key money could be included in the taxable assessment. The majority reasoned that the specific contractual rights did not stem from the independent business operations, but rather from the beneficial use of the property itself. If the contract revenue effectively flowed from the real estate's attributes rather than from independent enterprise activity, it's taxable. The taxpayer won on the methodology, so they split. The courts unanimously struck down the county's application of the Rushmore method, which did not, while it did not rule that the Rushmore method was per se invalid, they ruled that the counties cannot blindly assume that the management fees wiped out all of the intangible assets, intangible franchise value. They remanded the case to present evidence that the methodology accounted for the full value of the assets. So it was remanded back to Superior Court, and I think it's probably going to go back to the AAB for further findings. So those are the two cases that have, I believe, are probably very, very pivotal since we last updated the handbook in 1998. Next is basically a list of current board guidance on intangibles. Some are in our 501, our basic appraisal, chapter 3. We have some, the majority of it is in the 502. That is the advanced appraisal, and that's in chapter 6. And then we have a couple of LTAs out there. And we also have the board's unitary valuation methods, Appendix A, and that's exempt intangibles. And that is more for our central assessment duties that is carried out by the SAPD, state assessed entities. So in summary, the taxation of intangibles have a very long history. There are two fundamental principles. Intangible assets may not be directly taxed, and assets may be valued by assuming the presence of intangible assets necessary to put the property to beneficial and productive use. How these principles are practically effectuated is heavily fact-dependent. So when I said our basic guidance in our 502, Chapter 6, recognized intangibles, identify it, value it, and remove it, all of that is very, very fact-specific. The guidance and the rules should be uniform. The application depends heavily on the facts. So with that, I conclude my presentation. Mr. Moon and I are both available for any questions you may have.
Wonderful. Thank you so much. Really appreciate the time and put those slides together and present to this board and to the public on a very important history that dates back many, many years. I'm going to look to our board members. Do we have any questions? I know we were asking questions during. Vice Chair Gaines.
Just trying to understand this aspect of intangibles where there's a scenario where it's included in the valuation and then later subtracted. Is the valuation and of that intangible and the amount subtracted, is that the same number, or can that be interpreted in a way that it may not be a full deduction?
Yeah, so that's the crux of what we're gonna probably talk about in the next,
Okay.
for the rest of this afternoon. Just to bring it back to its most simple case, in that instance where we talked about a liquor license, it's a pretty clear example, and it's pretty easy to, it's a little easier to grasp than some of the very, very complex properties that we're gonna talk about next. In the case, you have a liquor license, it's a bar, you can sell liquor. If you appraise the property with the income approach and you actually use the income to the bar itself, how it's being operated, then there's a strong, strong argument that the liquor license is included in there because you have to operate with the liquor license in order to sell the alcohol. Now, how do you've identified it as a liquor license, it's an intangible, it should be removed. You got a couple ways of doing it. For a liquor license, it's amongst the easier of intangibles because there's actually a cost to the liquor license. You hold it and you can actually probably sell it. You can sell the liquor license, so there's a value to it. So if you think the bar is worth $1 million, and the liquor license alone is worth $100,000, then the taxable value of the real taxable tangible property should be $900,000. But that's the easiest it's gonna get. Everything from here gets tougher, how to basically identify, segregate value, and to remove.
And then also the type of valuation, whether it's cost or income.
Whether it's cost or income, in our guidance in the 502, we actually begin with, if at all possible, when possible and when appropriate, to use a valuation method that excludes intangible values in it already. The easiest one to point to is basically the cost approach. Typically, the cost approach would not, if you're looking at the cost of something, it probably would not involve an intangible. If you're looking to use an income approach, an income that's directly related just to that taxable property, just that real property in this case, in the case of a bar. If you're using enterprise value, then enterprise income, then there's probably, then the task becomes identify the intangibles, value it, to take it out.
Are there challenges to the method used then? By business
There are
owners or
many,
property
many,
owners?
yeah, there's many, many challenges. I think both the assessors and the practitioners are going to have, they're gonna, like, I hate to say this again, this is the easiest it's gonna get right here. Everything else from here,
Okay.
it's gonna be permutations and complexities on top of how to identify and how to remove,
Thank you.
of course.
Thank you, Vice Chair Gaines. Any other members have any questions? If not, I just want to pitch one myself. So in the Olympic and Georgia Partners case, there's a distinction drawn between intangibles that increase the going concern value of the business operating on the property as you described, franchise rights, customer goodwill, favorable management contracts, and intangibles that increase the revenue generating capacity of the property itself, like the occupancy tax agreement. The current Handbook 502 gives examples of the first category, but not the second. So how should updated guidance describe and illustrate both categories? And what factors should an assessor analyze to determine which category a particular asset falls under?
So I hate to deflect, but I think that's all part of what we would all like to hear, even as staff, from some of the testimony today about the kinds of things that have been developed since '98, the kinds of things that they look at, the kinds of things perhaps there's agreement on between assessors and the industry on what's available and what's helpful. And I think that's all part of the information that we'd like to consider.
Yeah, and that goes kind of into my next point about the updated guidance being structured as an amendment to the Chapter 6, a standalone new handbook section we should create, or a series of property type specific guidance documents, and what format would be most useful moving forward. And I leave this question open to the entire audience as we move forward. So I want to thank you, gentlemen. Really appreciate. Thank you, Executive Director Stowers, as well, for letting us borrow your staff for this. We're going to close out agenda item 2, but first let's go to public comment. Are there any members in the public in person that would like to comment on agenda item number 2? Please come on up. I believe we have Ms. Lee. And you can just come up on any of these microphones over here.
Good morning. Good morning, Chair and members of the board. My name is JC Lee with the California Taxpayers Association. Thank you for having me here today. Caltax has been involved in this issue for a long time, and we thank you for convening this board work group on valuing intangibles. Going back to 1991, Caltax and others in the taxpayer community engaged with the board on intangibles both on the administrative and legislative sides. As the board reflects on the long, difficult battle that eventually led to the passage of SB 657 and the adoption of Assessor's Handbook 502, we urge you to focus on the principle that became clear during this fight. Do not tax what the law says is not taxable. California continues to struggle with the question of whether assessors are valuing taxable property or additionally capturing the value of the business enterprise operating on that property. Such a distinction is not a mere technicality, but rather the difference between fair property tax administration and the taxation of value that the law says is not taxable. Particularly in light of disagreements between assessors who may misinterpret or disagree with existing case law, there is some urgency for the board to act to distinguish income attributable to taxable property from income attributable to enterprise activity or other intangible assets and rights. Caltax urges the board to take advantage of this work group to begin updating statewide guidance informed by lessons learned from California's history of disputes over the inconsistent treatment of intangible assets and rights. Thank you for the opportunity to speak, and Caltax looks forward to continuing our collaboration with the board to make clear that property tax remains a tax on real property and business personal property and nothing more. Thank you.
Thank you so much. Are there any other members of the public that would like to comment in person? Seeing none. Mr. Vasquez?
Yeah, real quick, just a quick question. I wanted to just, one, thank Mr. Young and Mr. Moon for their presentation. But in listening and in going over, especially some of the challenges we have moving forward, and I know staff is kind of limited in terms of their resources right now with other projects you're working on. Is it something that we, and maybe it's more of a question for our executive director moving forward, do we have the capacity to bring on like consultants to help in this, especially as we hear, I'm sure we're going to hear from a lot of folks, stakeholders that are looking at some issues, and as I'm looking at especially this, the fact that we haven't even revised, you know, the 502, I believe it was, you mentioned in the handbook. And I know it's something that's probably on your list, but I'm sure with everything else that's going on your workload, it must be a challenge. I'm just wondering if that's even a possibility moving forward.
So it is certainly a challenge. I don't know that it's a quote unquote hiring consultant issue. There's a plethora of expertise even today in this room and on Zoom from which we'll hear a lot of information. But regardless, I think it will take a long, so just as an example, when the 502 was done, that took 2-3 years. I think prior to that, in 91, 92, 93, there was rulemaking that went on that it didn't end up in a final rule that was promulgated. But you know, that effort took 2 to 3 years. The handbook took 2 to 3 years. And so regardless, I think this will be it will take a long time.
A long process.
Depending on what the board decides they want as sort of the final product.
Thank you.
Thank you so much, Mr. Vasquez. So seeing no other members of the public in person, let's go to the phone line. AT&T operator, are there any members of the public that would like to comment on agenda item number 2?
If you would like to make a comment, please press 1 then 0. Once again, for comments, please press 1 then 0. And one moment, please, for your first comment. And you have a comment from Kate Bell. Please go ahead.
Good morning. This is Kate Bell on behalf of the property tax agent firm Ryan LLC. I just wanted to say I appreciate the conversation. We're very much in support of the continued intangibles work group with the goal of updating the BOE Assessor Handbook 502, Chapter 6. We look forward to be coming to a resolution on this and greatly appreciate all of the work of the board members and staff. Thank you very much.
Thank you, caller. Operator, are there any other speakers on the line that would like to comment on this agenda item?
There are no other comments at this time.
Thank you so much. I want to thank both Mr. Young and Mr. Moon. We're going to go ahead and close out agenda item number 2 here. Before we move on, Assessor Torres, it's okay, we're going to take maybe a 5-10 minute break, and then you can get your team together and we'll jump right into agenda item number 3. So it is 11:02. Let's all come back here maybe 11:10, and we can all set up. See you in a few minutes. Thank you. Here it is. Here, there's the assessor. Good to go? Good morning, everyone. Thank you for taking the time. Hope everyone got a little caffeine, a little dessert, but we're gonna go ahead and get started in the words of Mr. Young, the more challenging parts of this. So, Madam Clerk, can we call agenda item number 3, please? And I want to welcome everyone back from break.
Certainly. Next up is item 3, County Assessor's Perspectives on Intangibles Assessment. Presentation and discussion from county assessors and county council on current county practices, challenges, and recommendations relating to the identification, valuation, and assessment of non-taxable intangible assets and rights. Our opening item will be a statewide perspective presented by the Honorary Joaquin Torres, Assessor, City and County of San Francisco and California Assessors Association. And then our item B will be navigating intangible assets across property types, common examples and valuation. And with us today, we have Albert Tapia, Division Chief 1, Commercial Valuation, San Diego Assessor's Office. Michael Trigueros, Supervising Appraiser 2, Appeals Division, San Diego Assessor's Office. And then we will also have Putting Legal Developments into Practice, and our speakers will be Carol Ruart, Deputy City Attorney, City and County of San Francisco, and George Renke, Chief Deputy Assessor, Los Angeles County Office of Assessors. And wrapping up this topic will be operational challenges of intangible valuation with Michael Daly, Chief Deputy Assessor, Santa Barbara County Assessor's Office, Mike Munoz, Senior Deputy County Counsel, Santa Barbara City Council, and Jennifer Tidingo, Chief Appraiser, Napa County Assessor's Office. And I believe they've brought additional folks with them, so I'm sure they will introduce themselves if they will be speaking.
Thank you so much, Madam Clerk. All-Star Squad here. Welcome you all to the chamber as well. Mr. Torres, is there anybody online that you wanted to recognize?
Not at this time, no. But as speakers are making their way to make comment, they will also be introducing themselves as well.
Thank you so much. So, want to hand it off to you, Assessor Torres. Really appreciate it. Great representative coming out of the City and County of San Francisco, and also the CAA. And I'll let you lead this group how you want to. So, the floor is yours. Thank you.
Great. Thank you so much, Deputy Controller Imran. Good morning, Chair Lieber, Vice Chair Gaines, Member Schaefer, Member Vasquez. I hope that we have a nice flow for you today in terms of our presentation. I'm Joaquin Torres, the Assessor Recorder for the City and County of San Francisco, speaking on behalf today for the California Assessors Association. I want to thank you all again for the invitation to join you in this discussion. This working group brings together assessors, county council, property owners, taxpayer representatives, Board of Equalization staff, and the board because we share this common objective: ensuring that California's property tax laws are applied fairly, equitably, and transparently. As you've just heard from David Young and Richard Moon, the California Constitution and state law are clear. Assessors must value all non-exempt real and personal property at fair market value, while not directly assessing so-called intangible rights and assets. California has a long history in this area, grounded in two fundamental principles. Intangible assets may not be directly taxed, and assessors may assume the presence of the intangibles necessary for property to be put to productive use, as you've just heard. But applying those principles is highly fact-dependent, and that is precisely where the real complexity lies. The core question is straightforward. When a unit that is bought and sold in the marketplace, such as a going concern business operating on land and buildings, derives value from both taxable property and non-taxable intangibles, where does the taxable property end? And where do the intangibles begin? In a going concern sale, the purchase price reflects both tangible assets and complex intangible elements, which is why separating these components correctly requires a judgment of trained appraisal experts. This is a challenge that's isolating. The challenge for us is isolating, measuring, and separating those intangibles from the taxable property. Doing that well requires careful application of established appraisal techniques across the income, cost, and comparable sales approaches to find the true value of the taxable property within the operating business. While the framework is well established, applying it across different property types, business structures, and information sources can be complex. It is complex, especially when the data available wasn't created for property tax assessment purposes and doesn't reflect the distinctions assessors and appeals boards are required to make. Our role today is not to advocate for a specific outcome. Our role today is to share practical context that's grounded in our collective experience, which is substantial. You're going to hear from assessors' offices and county council with decades of that experience, administering these principles across a wide range of property types, market conditions, and assessment appeals. These issues are not theoretical. They arise every day in the practical administration of California's property tax system and the application of its laws. Our presentations are going to focus on three questions. First, where do these issues arise? Second, what do the law and recent cases actually tell us? And third, what practical challenges still remain? Ultimately, our goal for this workshop is to help establish a shared foundation for the board's ongoing discussions and to identify opportunities to improve clarity, transparency, and understanding throughout the assessment process. So as we continue this dialogue in future sessions, one of our aims is to promote a common understanding of evidence and analysis needed to address intangible asset issues. Clear expectations support productive, good faith engagement. And the more we can align around a shared understanding of these issues, the more constructive and collaborative the discussions will be for everyone involved. So thank you very much, and I will now hand it over to our first section of our presentations.
Thank you. Good morning. Good morning, honorable members of the State Board of Equalization, and thank you for this opportunity to share a comment on such an important topic and give our perspective. My name is Albert Tapia. I'm a division chief with San Diego County Assessor's Office. I have about 25 years of experience, and I hold an advanced certification from the State Board of Equalization. I also have here with me Mike Trigueros, supervising appraiser 2, heading one of our appeals teams. So he's got front row experience of dealing with this issue on a daily basis. This experience that we both have, which is approximately more than 50 years of appraisal experience, has given us a front row view of how intangible issues emerge in these complex valuations. And these issues can have a significant impact on the taxable value. With that in mind, I'm going to jump to our first slide and define intangibles. What are intangible assets? Can we proceed to that one there? Thank you. As I look across industry resources, I see that a concise dictionary-style definition doesn't appear in Assessor's Handbook 502. However, the handbook does provide examples, noting that intangible assets and rights include such items as goodwill, patents, certain licenses, and franchises. I also looked at the Appraisal Institute, and the Appraisal Institute describes these as non-physical assets like trademarks, copyrights, and similar rights, distinguishing them from physical assets such as facilities and equipment. I also looked at the International Association of Assessing Officers that offers a more detailed definition, framing the intangible property as property with no physical existence that may represent rights over real property and personal property. Across the three resources, the consistent takeaway is that intangible assets and rights are non-physical items, such as trademark, patents, licenses, and franchises. Overall, these concepts are fairly consistent, and we look forward to continued guidance from the State Board of Equalization to ensure we identify these intangible assets consistently and remain aligned with the appraisal community. Having discussed what intangible assets are, the following slide represents a list of common property types which applicants often claim intangible assets. Next slide, please. So this is not a comprehensive list of all the asset types, but these assets, these property types, we commonly see claimed intangibles. In San Diego County, the type of properties we commonly see intangible assets claimed are hotels, amusement parks, golf courses, and that's due to our strong tourism sector. But we've also encountered significant intangible claims in assisted living facilities and student housing projects. What varies widely, though, are the categories of intangibles being asserted, as well as the percentage of total value applicants claim. Okay, we are also continuing to see claims that expand into additional property types. This trend makes it even more important that we clearly distinguish taxable property from the non-taxable intangible components. With that in mind, how these issues interact with the three approaches to value. Next slide, please. On this slide, I'm providing a quick overview of the three approaches to value and the issues that arise with each when intangible assets and rights are involved. With the income approach, the first question is whether the valuation is based on operating income or rental income. The distinction matters because operating income from a business enterprise may include revenues tied to intangible assets, not just the real property. On the next slide, you can go back, apologies. On this slide though, on the next slide, I'll show examples of intangible items that often appear when you use operating income to derive a going concern value. In contrast, rental income, like the one you would see in an apartment building, reflects income attributed to the real property itself, not the business operation. This makes rental income-based valuations generally more aligned with isolating the value of the taxable real property. With the sales comparison approach, a method that estimates property value by comparing sales prices of similar properties, the question is whether sales prices include intangible assets. And if so, how do we adjust those sales prices? With the cost approach, the property value is estimated by calculating the cost to replace and reproduce structures or improvements, less depreciation plus the land value. Since this method only focuses on taxable real property, the cost approach avoids the issue of excluding intangible assets and rights. Next slide, please. As I mentioned earlier, when using operating income in evaluation, it might capture components beyond the taxable real property. This can be intangible, it can be tangible personal property, intangible personal property, financial assets, and working capital. These elements collectively contribute to the going concern value, which is appropriate for some valuation purposes, but it may require adjustments for property tax assessment. The key challenge for assessors is ensuring that only taxable property is included in the assessment. Now, I'm going to hand it over to my colleague, Mr. Mike Trigueros, to provide you some real-world examples of what we're seeing every day and the reason we need more guidance so that we can have uniformity.
Good morning, Board. Thank you for having us here today. Michael Trigueros with the San Diego County Assessor's Office. Can you flip to the next slide, please? So we thought there was some benefit in giving you a visual of some real-world examples of what I'm seeing on the ground as I'm doing my job on a daily basis. This is an example of two luxury hotels with golf courses. On the left box, you'll see that's applicant 1, and on the right box, we've identified that as applicant 2. These properties were valued by the applicant using operating income to derive a going concern value, basically the top line value of that enterprise running the hotel property. And within that value, or after arriving at this going concern value, the methodology is to identify value and remove the value of the identified intangible assets. And this is from the applicant's perspective here. On the left, applicant number 1 identified an intangible asset for a flag and franchise agreement. Applicant number 2 on the right identified a similar asset, however named differently, a return on brand and trade name. And this is one of the things that we wanted to highlight, is that if there's a sea of terminology that's being applied here, those are essentially, at least appearing to be the same intangible that they're claiming. On the next bullet point on applicant number 1, they claimed an intangible asset for return on furniture, fixtures, and equipment, or the FF&E. Applicant number 2 on the right claimed a similar intangible. He called it return on tangible personal property. Going down to the third bullet point for applicant number 1, they claimed an intangible asset for return on management. Applicant number 2 notably did not claim this same intangible asset. Again, these are very similar properties, both luxury hotels with golf courses. One applicant's claiming a return on the management, applicant number 2 is not. Going down to the fourth bullet point for applicant number 1, they've claimed an intangible asset for food and beverage operations. Looking to applicant number 2 on the right, they have not claimed this intangible asset. So again, we have 2 similar properties, similar amenities. Applicant number 1 claims an intangible for food and beverage, applicant number 2 does not. Going down to the last bullet point for applicant number 1, they've claimed an intangible asset for the assembled workforce. Applicant number 2 on the right did not identify this intangible asset. So you see the I don't want to say they're inconsistencies, but they're just differences, I guess, in what the applicants are seeing in their analysis and presenting to my office to consider as intangible adjustments. Applicant number 2 on the right also identified several additional intangible assets that applicant number 1 did not. Applicant number 2 identified an intangible for return on and of initial investment costs. This is a hotel is probably 40 years old. And so applicant number 2 also identified a return of and on advanced bookings, which applicant number 1 did not, return on resort membership fees, and return on other intangibles. In total, applicant number 1 claimed about a 22% of value of intangible assets from their going concern value estimate. Applicant number 2's claim for intangibles is about 28%. Flipping to the next slide, please. This is another example of a property that was valued by the applicant using a rental income. So this is a student housing property. The difference here is the prior slides was they were using operating income to value the hotels. This is rental income from a student housing property. Yet they've also identified intangible assets here. They've identified an intangible asset for return on and of initial investment stabilization costs, return on tangible personal property, return on brand and trade name, return on non-real estate NOI, and return of other intangibles. And the total value of the intangible assets claimed here was 14% of their total top line value that was derived using rental income. So these are the sort of intangibles that are being presented to us that we're required to grapple with and try to sort it out. So that's one of the main issue that I face in my daily work. Flipping to the next slide, please. And I think maybe a better title for this slide would be, what can we do as a working group to create fair and equitable guidance for property owners, tax representatives, and assessors? And we can provide more guidance on assessing the value of real property when using operating income while excluding any non-taxable intangible assets and rights if they are present. We can distinguish between intangible assets and rights necessary for the productive or beneficial use of the taxable property, and those that only enhance its value. We can provide clear guidance on how to identify non-taxable intangible assets and rights, along with establishing requirements for documentation and valuation evidence. And we can create a process where information on intangible assets and rights is provided in advance from applicants so that the assessor's office can grapple with those intangibles. And when property valuation involves operating income and significant intangible value is asserted, we can focus on a methodology that isolates the real property value only. And with that, I thank you for your time today. I'll pass it on to Mr. Rankin.
Thank you.
Good morning, Madam Chair. Good morning, members of the board. My name is Carol Ruart, and I am a Deputy City Attorney with the City and County of San Francisco, here representing the city's assessor recorder, who you just heard from. By way of background, I've been practicing property tax law for over 20 years, including at the State Board of Equalization. I served as counsel for the First District Board member and senior tax counsel in the legal department. And my colleague, George Renke, will provide his introduction.
Thank you. George Renke, Chief Deputy Assessor for the County of Los Angeles. I've been with the county for 37 years now, so I've been through much of the recent history of these developments and the case law, and obviously the most recent decision that was discussed previously that we'll also touch upon.
We really appreciate Mr. Moon and Mr. Young's overview of the general legal principles and the history of how we got here, so we won't go over that again. And our colleagues from San Diego have shared with you the framework of intangibles analysis, which we'll really appreciate. We're here today to talk about why is case law so valuable and what role does it play? Here's a reference, this first slide is a reference to some of the cases that you may hear being referred to today. It's not a complete list, but as you can see, there are quite a few, and they cover various and possibly unexpected property types, everything from the cable television franchise to a concession to a state-assessed wireless company to a landfill permit to a liquor license, a film negative. If you'll please go to the next slide, there's even more. The case law spans a broad range of properties and businesses and intangibles, with Elk Hills Power being discussed previously. As you can see, many of the more recent published cases have been involved hotels, although we do want to note that although those recent cases are usually involving hotels valued using an income approach that we're going to focus on in our presentation, just as an example, that there are a number of Superior Court and Court of Appeal cases currently pending. So the law does continue to actively and timely develop. And it's not just historical property types in these pending cases, hotels, cable television, but new property types such as data centers and embedded software are involved in these court cases that are pending. So we're looking forward to even more judicial analysis coming relatively quickly down the road. For the next slide, here are the general principles that Mr. Moon and Mr. Young explained. And as more and more of these cases are being litigated, what we're finding is that the courts are increasingly focused on the nature of the claimed intangible. In other words, how is it related to the real property versus the conduct of the business? What evidentiary proof is being offered and what is needed? What intangibles exist? What are their values? And does the appraisal methodology appropriately value the taxable property? Remembering that all of this discussion of intangibles is merely to assist the assessors to isolate the value of the taxable property that the assessors are charged with taxing. We hope to give you a sense of what county assessors look for in these cases to help them accurately valuable taxable property. We're going to use the example of separating out value from an income stream of what derives from the real property itself versus the operation of the business enterprise using the property. And we're also going to take this opportunity to explain a few more terms that you may end up hearing in this process. Next slide.
All right, so our initial focus was on the income approach, and much of this has already been discussed, so I won't go over it in detail again. We'll just try to add to what's already been discussed. So our focus on the income approach is the income generated by the property itself and its beneficial use. The assumptions in the income approach that involve some intangibles is the legal assumption that the property is being managed competently and the presence of intangible assets or intangibles that were previously discussed that are necessary to put the property to productive use.
Next slide. So to that end, we're focusing on this generally applicable rule. What must the assessor do? The assessor must deduct from its income stream analysis any revenue that is derived in large part from enterprise activity, but must include the earnings from the taxable property itself or the beneficial use thereof. This is a fairly clear statement that comes from Elk Hills Power and was repeated in the Olympic and Georgia Partners case. This is just a reminder that what we are doing is we're starting from the overall income of the business as a whole, and then trying to remove intangible derived and enterprise derived income while keeping in the income from the real property. I thought this might be a good place to address Board Member Gaines's question earlier, where I believe the question was, when you have an income stream that has, that there's income included for a quote intangible, can the deduction for the intangible be less than what was included in the first place? So here's where the courts have shown us and confirmed for us that the data that businesses have for their own operational purposes does not always align exactly with the distinctions that the county assessors need to make in order to isolate the value of the real property. And so it is entirely common to have a particular profit and loss statement income stream that's labeled something, food and beverage or whatever, that at least has some acknowledged intangible attributes. But the job of the assessor is to recognize, as the courts have, that part of those earnings are related to the real property, part of them are related to the operational business. And this derives most directly from the Elk Hills Power case, but it predates that, Service America, concessions, et cetera. And what the courts teach us here is that we have to find a way, even if it's difficult, to impute income to the real property or parse the income between the two, that it may not be very easy, but the courts are inviting the assessors to do so. And so that is another area where I think there can be some productive discussion between all of the parties as to how do we take the data that's presented to the assessors and understand why the inclusion is one amount, the deduction is less. That's because some of that income is properly associated with the real property. Next slide.
Okay, and then expanding a little bit further on the assumption of the presence of intangible assets necessary to put the property to productive use. A couple of those examples are licenses and permits. We talked about licenses earlier in the example of the liquor license. An example came to mind as we were discussing that, and the assumption of a sale, and I believe the amounts that were put out in the previous example were, assumed that the bar is worth $1 million and the liquor license is $100,000. I could then also look at the sale of the bar. I don't know, basically on the sale itself, whether or not the liquor license may have been included in the sale or may not have been included and may have been done separately. So I may have the bar and the license selling for, let's assume, $1,100,000. If that was the sales price, then I would need to look at the agreement, see that the liquor license was included in the total sale, and then deduct the value of the liquor license itself from the total sale to get to the $1 million. So I would deduct the $100,000 value of the liquor license, and I would enroll the $1 million. I may have another scenario, same property selling, where I have an agreement to sell the bar for $1 million and a separate agreement for $100,000 for the liquor license. So now in this case, I have a sales price for that property, the $1 million, which represents just the real property with no consideration for the liquor license. But again, I would need to analyze the contracts to recognize that the $1 million was for the property and that there was a separate agreement for $100,000 for the liquor license to know that I didn't have to deduct anything further from the $1 million and I could enroll that as the total sales price for the property.
Next slide.
Oh, sorry.
No, it's okay. That's okay.
Going on then to income attributable to real property, again, that other examples are attributes such as zoning and location. We've touched upon that a little bit. We also had the topic of payments derived from intangible assets that are attributable to the beneficial use of the property. This came up as the occupancy tax that was returned to the developer of the property, and the court's conclusion that these payments were based on the beneficial use of the property, and therefore it was appropriate for the assessor to include that in the income for this property.
Just clarification on that. The 14%, is that a total occupancy? Is that a tax?
Yes.
Yeah, okay, so that would be returned to the jurisdiction?
To the developer. So that amount would usually go to the city. This is a
Yes.
city tax.
Okay.
In this particular property, to give an incentive for the property to be built,
Okay,
that amount is returned to the developer.
okay, all right, thank you.
And the helpfulness of that example, I think, reaches to Mr. Emron's point earlier about the case law up until the most recent cases has perhaps tended to focus on the intangibles, the identification, evaluation of the intangible and enterprise assets. And where the Olympic and Georgia case, and to also some extent the SHR St. Francis case, are very helpful is that they identify assets that are an income that is attributable to real property and why it's attributable to real property. So for example, this 14% room rate tax, that's a transient occupancy tax that's paid, it's, supposedly by the customers, paid by the customers, the guests to the city. The city entered into an agreement with the developer that they would rebate this tax every time a guest rented a room. And there were contracts and, all kinds of intangible, not just assets that you could identify, but you could separately value it. And in fact, in this case, the income stream was able to be transferred separately from the hotel, supposedly. So a lot of the theoretical attributes of non-taxable intangible assets could be ascribed to this agreement. But what the court was, I think, very thorough in their analysis about was to say, regardless of all of those attributes, and regardless of the fact that, according to the evidence, the agreement was made in order to help the hotel get constructed and not necessarily for guests to stay there, although that was a part of it too. The actuality of the way that the income flowed to the developer was it only flowed when guests actually used the property. The property was beneficially used. And so that was a very helpful description and framework and a concrete example of where we find an income stream that's attributable to the property and should be included.
Excuse me, what happens when in some cities where they pass a tax that they attach to the TOT tax? For example, in Santa Monica, we had a bond, or a measure on the ballot that increased, the TOT tax, I think might have been 12% or something, and they attached an additional 2% to that was earmarked for the schools. Does that get calculated, or is that a ding on the owner? Because you're saying right now it's being returned to the developer.
So here's the distinction about this Olympic and Georgia agreement is normally a transient occupancy tax is imposed, on the guest or in connection with the guest stays, and it's paid to the agency, the city or the county that imposes the tax. It doesn't go to the owner of the hotel.
Right.
Here, the tax did go to the city. Structurally, it went to the city, and the city agreed that it would take that money and pay it back to the developer. So the income isn't in the tax from the guest to the city. The income to the property is the city giving money to the developer every time a guest stays at the room. It happens to be measured by the transient occupancy tax, but that's almost immaterial. They could have agreed to pay $14 to the developer every time a guest stays at the room. And that was the helpfulness of the analysis. If you as the owner are getting money from somebody every time the property is beneficially used, that's income that should be included in the tax when calculating the taxable value of the real property.
Even though you have a measure that restricts some of that. For example, like I said, we had measures that were on the ballot where they earmarked the dollars. So even though you're saying they have to return it back to, in this case, I guess it's the developer, right?
But that was my understanding from reading the case is that was more contractual. In other words, the tax went into a fund, and then the city said, we have money in this fund, we're going to write a check to the developer every time that the guest stays in the room.
Incentive to build the hotel, I would imagine.
That was the underlying purpose, but that was not, again, it's easy to kind of look at that part of it and not look at the final fundamentals, which is every time the guest stayed in a room, the owner would get whatever the guest paid, and they'd get whatever the city paid, 40%, $14, whatever it is. And what the analysis, why it was so helpful was it really talked about, regardless of where the income comes from, it's still income to the developer, and it still only comes to you when the property is beneficially used. And this mechanism of it was through a tax and there was a contract and all this is it's important to analyze. Sometimes it's important to analyze all that complication to understand what is not relevant to taxing the real property. And this is where the nuances really come forward, is that to get to that point, for the court to get to that point, they had to, the assessor and the taxpayer and the lower courts and the assessment appeals board really had to look at a lot of information, both contractual and factual, about what this arrangement was all about. And we came up with a very clear rule, but boy, was it a hard row to hoe to get there. I mean, I'm not speaking for Los Angeles County, but would you say so?
Yes. Definitely is. That really takes us to the next slide and really leads us right into it, which is, we can go to the next one. That really these need to be evaluated on a case-by-case basis. The topics that we were discussing with this particular property, with the occupancy tax and also the key money were very unique issues to this particular property that needed to be analyzed and understood. And compared to the market in general as to how those things should be handled in this particular case as opposed to other cases that would likely not include those particular issues. So that we have general framework and ways, and the courts have given us guidance also on how this should be evaluated, but it's very difficult to just come up with a general rule as to you can do this every time and you'll get to the right answer. The real key to this is really looking at the particulars of the situation. Like the one I gave you earlier with the liquor store is, as was mentioned, that's as simple as it gets. With the hotels, it becomes much more complicated where, it requires us to really look into the particular facts of, the subject property as well as our comparable sales in comparison, how the comps were analyzed, how the subject should be analyzed, how the methodology is being applied, and to make sure that it's being done in a consistent manner throughout the state. So that's really the bottom line challenge that we face.
And to be fair to the Olympic and Georgia court and how the assessors and taxpayers need to interpret it is, even with that occupancy tax analysis, the court was quite clear that they were limiting their holding to the facts of that particular situation. And they stated quite clearly that we do not opine as to how any other types of agreements, even if they look similar, might turn out. And so the courts themselves are giving and taking away at the same time. But the central message is it is absolutely case by case and intensely analytical and fact specific.
Going back to Mr. Reinke's point, so in your opinion, do you believe the most difficult property type is hotels when it comes to intangibles?
I would say more so that the topic of intangibles, and we run into it fairly often with hotels, so that adds a complication to hotel valuations. But it does come into play on other types of properties also.
Okay, thank you.
Yes.
Along those lines, I think earlier one of the speakers was talking about, I think it was you in San Diego, Mr. Mejia, you mentioned, you didn't give the names, but you cited an example of a hotel with golf course. I'm assuming you're talking like Torrey Pines, for example, which is in San Diego. Is that connected to one of the hotels where you were referring to?
No, sir, that was not.
That was totally different?
Yeah, it was separate from Torrey Pines. And the golf course in Torrey Pines is owned by the city and leased separately.
It's separate, right?
Yes.
Yeah.
Next slide. Okay. This is just a break in the heavy analytical action, maybe. This is hopefully a helpful note on some of the terms of vocabulary that you're going to hear in these, and you already have heard today. We're calling this a note on the so-called, quote, Rushmore method. This is a term, the Rushmore method, that in our experience, we found can be used rather loosely. It's often used, and the originating concept was that payments in a hotel for management, maybe sometimes the franchise, that can account for all of the intangibles related to the hotel's enterprise activity, the business of the hotel. You paid somebody to manage it, that takes care of every single intangible asset related to the hotel's business side. And so once you deduct that value, however you do that, then everything else that remains is taxable real or personal property. It can also be used to describe a method where the management agreement and franchise value accounts for some of the intangibles related to the hotel's enterprise activity, but not all of them. We noted that, and Mr. Young noted that no court has categorically rejected this method, either version of it. But what we've noticed is that the trend appears to be that the courts are seeking evidence as to each identified intangible asset that is claimed to be accounted for by the management or franchise fee. And that they're looking very closely at both the methodology and the justification of how these claimed intangibles and the management and franchise fees are being related and accounted for. And so we just wanted you to be mindful that when you hear the term Rushmore method, just you want to verify exactly which Rushmore method are we talking about? Are we talking about categorically, as a matter of law, management fee takes care of all intangibles related to the business, or is it more nuanced and applied a little more finely? Next slide, please.
So practical implications for assessors and taxpayers. For assessors, there's the need to consider credible evidence of the existence of intangibles when it's presented to us. The need to analyze the nature of the intangibles in the relation to the real property and the enterprise. Again, as was mentioned just a moment ago, Rushmore approach still remains valid, but requires appropriate analysis of the particulars, as we were saying before, on a case-by-case basis. For taxpayers, the offer of credible evidence of the existence of the intangibles in question cannot exclude value just based on categorical rules. And also the necessity of the information that the taxpayer possesses about the particulars of how the property operates, or the particulars of a sale of a property that includes intangibles.
And finally, the final slide. So after the decades of statutory development and judicial interpretation, we still have the recurring question. Are we valuing the productive use of the real property, or are we including valuable that's attributable to intangible enterprise assets? This is the essential framework that the recent legal developments in California are focused on, and that it is why assessors look to case law to help them. Case law is valuable and essential to applying these abstract principles to the evolving real-world developments. And perhaps the most important principle that we glean from all these cases is, as we keep saying, it's a fact-specific, case-by-case exercise that relies on factual information and analysis that's tailored to different properties and assets. But all of this focus on the intangible and business enterprise assets is in the service of reaching a fair and equitable and accurate assessment of the property that the assessors and this board are constitutionally charged with assessing. This is why we are here. Now we will hear from our colleagues from Napa County and Santa Barbara County on the operational challenges in reaching accurate assessments.
Good afternoon, Chair Lieber, members of the board. Really appreciate the opportunity to be here today to present. My name is Michael Daly. I'm the Chief Deputy Assessor in the Santa Barbara County Assessor's Office. I have an advanced appraiser certificate. I started as an appraiser 1 13 years ago, so I've been with our office 13 years. It's been a fun 13 years dealing with intangibles. I'll have Jennifer introduce herself.
Good morning, board. Jennifer Tidenko. I'm the Chief Appraiser for Napa County Assessor's Office. I'm also the president of the Organization of Chief Appraisers under the CAA. And I have, close to 30 years appraisal experience, nearly 20 in the assessor's office. Fun fact, my initial interview was September 11th, 2001. So that was a really interesting day for a job interview, and I'm very thankful to where it got me now. Together, Michael and I, Mike Munoz is not here. He is present online, I believe, but he is not here with us today. So Michael and I will be presenting the operational challenges that assessors' offices face when dealing with properties that may include non-taxable intangible assets, and the ways that we believe that the BOE can help guide us so that we are able to alleviate some of the challenges we all face, and then that we are doing it in a fair and equitable manner.
Thanks, Jennifer. Yeah, Mike Munoz is our county counsel, and he couldn't make it today, but he did help contribute to our presentation today. So just let me briefly frame what we're going to cover. Our presentation is about a practical problem. How do county assessors identify, analyze, and properly determine the assessed value of real property while not including the value of non-taxable intangibles? What makes that difficult? You'll hear a lot of what you've already heard today, unfortunately, but we're hoping to bring it from the perspective of the operational challenges assessors' offices see, the staff that are working on these valuations and assessments. So we're going to go through 3 areas. First, we'll start with the operational challenges we encounter, identifying the intangibles, dealing with evidentiary gaps. That's a big one. You've heard a lot today about facts and evidence, so you'll hear more about that. And then the resource burden and the resource constraints we have in our offices around this issue.
And then after that, we will cover areas where we believe updated BOE guidance could meaningfully support county assessment administration.
So let's start with the challenges, and we can go to the next slide. Here's the 3 categories I mentioned. So starting with identifying intangibles. Many property purchases of this nature involve a going concern. You've heard that term today, a hotel, a winery, a medical practice. You saw all the different property types. But there's no universal, clear trigger that tells an assessor to investigate whether intangible assets are present. Every property, every transaction is different. We don't have a checklist that says this type of purchase always warrants an intangibles review. Our staff can spend significant hours investigating transactions where ultimately no meaningful intangible value may exist. And on the flip side, intangible value can be overlooked entirely because it simply isn't apparent from the recorded documents or from what the taxpayer or property owner has voluntarily provided to us. On the lack of evidence, this is the central operational tension. Whether we're dealing with a transfer or new construction or an appeal or a lien date, all these different event types that these assessments come up in, the burden of production and proof rests with the property owner. The assessor needs accurate, truthful information to do this work, and that means the property owner must grant us access to it. We can apply the applicable valuation methodologies. We can interpret an agent's analysis, but we need actual, factual evidence to evaluate whether a claim has merit. And purchase price allocations are not in and of themselves a valuation method. Under the R&T Code, Revenue and Taxation Code, Section 501, we can only move forward with the best information we've been given. We're entitled to both quantitative and qualitative information, and when that's withheld or delayed, we're simply left to make assumptions. Finally, the resource constraints. These valuations, these assessments, and often appeals cases, that's where they end up, they're very resource intensive. They often require all 3 approaches to value. That's the cost, income, and sales comp approach you saw earlier. And the review and preparation work for appeals can be extraordinarily time consuming. Our primary focus, as you've heard today, is real property for tax purposes. And these complex cases can stretch timelines considerably. We want to be clear about this. We get the work done. The work's getting done, but it would get done faster and more accurately if property owners provided the requested information in a timely manner.
All right, thank you, Michael. Next slide, please. So now what we would like to do is next slide. Is that?
Oh, it was back.
Oh, back one, sorry. I did. There we go, thank you. So now what we would like to do is to address these challenges, and we'll organize this around 3 main areas: standard framework, clarifying resources, and market evidence. What we're asking for is guidance from the BOE regarding intangible analysis and the documents that are reasonably necessary to support intangible claims. Beyond that, we'd benefit from standardized screening criteria, a checklist of property types where intangible analysis should routinely be considered, and practically speaking, a standard statewide information request template and reporting structure would go a long way for consistency and efficiency across counties. On clarifying resources, the existing BOE guidance, and I think this is why we're all here, and educational materials need to be updated to reflect modern transactions, current information sources, valuation methodologies, and the most recent case law principles. The landscape has changed significantly, and our staff, as well as assessment appeal boards and property owners, deserve resources that reflect where we actually are today. We'd like to see those materials made broadly available to all stakeholders, not just assessors. On market evidence, examples of actual market data and the applied side of the work. We need real-world examples of market data and information that valuation professionals actually rely on. We need illustrations of accepted methodologies using all approaches to value, along with honest discussions of the strengths and weaknesses of each of the primary approaches. We'd also welcome specialized training and advanced appraisal courses tailored to this work. And we want to underscore this point: no single approach or method fits every situation. We're not asking for a rigid formula, but we do need basic agreed upon guidance on how to identify and value property that includes intangibles, guidelines for our staff to inform the appeals boards, and to give property owners a fair and transparent process.
I just want to add real briefly, you heard from Mr. Jung this morning, something that definitely I think warrants reiterating. On his very last slide, he said, how these principles are applied is heavily fact dependent. That's a really important point we're stressing here. Facts and evidence. Absent accurate, truthful facts about what's going on, particularly when there's a change in ownership, a purchase, it makes our jobs exceedingly, extraordinarily difficult. And we're left to just operate with assumptions, which the law prescribes to us. So to wrap up, we can go to the closing slide. The issues we've discussed today are real and difficult. They're recurring, but they're manageable with the right support. We're committed to doing this well. We're committed to, it's not just about the assessor. We see the property owner. We see the appeals boards. We see the struggle, the difficulty with this. It's not one-sided. We all need the tools, the guidance, and the cooperation to do it efficiently and consistently across the state. So we look forward to continued dialogue and future workshops and the opportunity to participate.
Yeah, and to conclude, thank you for your time today, and we're here for any questions that you may have.
Thank you. Very well done. Assessor Torres, I'll let you close this out.
Oh, no, I think we're ready to take any questions that you may have. And again, thank you for the opportunity. I hope that we presenting with you a very kind of cogent flow of the issues at hand, so we can continue to be part of a productive conversation on addressing the issue of intangibles.
Wonderful. Thank you so much. I'm going to turn to our board members. Do we have any questions? I know we're chiming in between the presentations. Member Chair Lieber.
Thank you. I have a question for Assessor Torres. In your experience in working with the CAA, how are less populated, less well-resourced counties meeting these challenges?
I think it all depends on the counties that we were speaking of, but I'm going to defer a little bit to counsel over here in terms of the conversations that she is having with counterparts in those counties as well.
Mm-hmm.
I could certainly do that, but perhaps first we can hear from our colleague in Napa, a classic small county.
Yeah, so how we're dealing with them, in our office, we're a small office. Napa is well-known. Napa is a high-value county, and we are a very small office. It is me, a supervisor, and 8 appraisers tackling every assessment in the county. And when we have appeals, it often ends up in appeals on these really interesting properties. It is so time-consuming, and we're just doing the best we can. As president of the organization of chief appraisers, small counties end up in the organization like what I'm the president of. We're meeting, we're having to travel all over the state, to get together so we can figure out how the best to do it. And it is a struggle, to be perfectly honest. It is a significant challenge. And there is like a lot of money on the line. And we just want to do what is right and what is fair and in accordance with the law, in accordance with the guidance that we have.
Okay. I was thinking of a small county as Trinity or, much smaller than Napa, but I'm surprised by the size of the staff in Napa because that is a high-value county, for sure. Yes.
If I may, Chair Lieber, I think that's a really fair question. And, of the 58 counties, it's, there are certainly smaller counties that I don't think they really deal with this issue the way other counties do that have these, property types. But it still remains a statewide issue.
Great.
And also, Chair Lieber, certainly for the counties, I mean, the resource constraints are real. I mean, many of us are having ongoing conversations that are unfortunately concluding right now, not favorable completely in our direction around having our legislative bodies understand the resource needs that we have and the associated benefits to counties that are provided when we are well-resourced to do our jobs efficiently. So I think this is an ongoing conversation for us across the state, in addition to our individual conversations within our own counties. But also just want to make sure that we also assembled a group here across the state, so you could get some both geographic and differentiation from counties who can express both their at-large experience with this issue, but also add some of their own individual texture that the counties are experiencing as well.
Yeah, absolutely, and it's always very valuable for us to understand the statewide resources challenges and requests of the legislature and those associated issues. So we'll keep in touch.
Thank you.
Thank you, Chair Lieber. Member Vasquez.
Thank you, and thank you, Assessor Torres, for putting together this all-star team here before us today. And as we look at the topics, especially the hot topics under the intangibles, what would you say are like the top priorities statewide? Because, we got small, the medium, the large, looks like all represented here.
I think just based on the presentation that we've had in the slides of listing the major key challenges for us in those 3 areas that we've discussed thus far. But I also want to be clear, this has been a joint effort. It's not one singular person. I want to thank Los Angeles County, in addition, for helping to organize us being here today. To that end, Mr. Renke, do you have anything else that you would add here in terms of any additional detail around challenges other than what we presented right now in terms of those large, comprehensive issues that we're seeking to address?
I think we've given a good representation of the issues. I'm sure the subsequent conversations will get much more detailed, and we're prepared to engage in those conversations.
Okay.
Thank you, Member Vasquez. We have a person with their hand up online. Assessor Torres, do you recognize Daniel Winderhoff?
Daniel Wiedenhoff?
Yes.
Wiedenhoff.
Certainly.
Yeah,
Are you
I would
are
just
you
like
part
to
of the
add some-
Agenda 4 item?
I am not. I thought this was a point in which I could interject an idea that might be helpful.
Is it the private sector folks? I just want to identify who you are and if it's going to be a public comment.
Daniel Wiedenhoff. I'm Daniel Wiedenhoff, agent with ProTax. I'm a director. And I just wanted to interject, if possible, something that I think might be helpful to the situation.
Assessor Torres, if that's okay? Can-
If it's more appropriate for public comment, we can hear it there.
Yeah, we're just gonna come up, Daniel, we're gonna come up to public comment in just a few moments, so we can wait for that. And
Fair enough.
we'll
Okay.
appreciate that. Thank you so much. So let's actually go to public comment if there's no other questions. Are there any members of the public that would like to comment on this agenda item number 3, in person? Seeing none, I'm going to close public comment in person. Let's go to the phone line. AT&T operator, are there any members of the public that would like to phone in on agenda item number 3?
To make a comment, please press 1 then 0. And at this time, no one is queuing up.
Thank you so much. So Daniel, you can go ahead and give public comment. I believe it is 3 minutes when you're ready, okay?
No problem. Okay. My public comment is this. I think one of the things you ought to consider in dealing with the situation statewide is something like the ownership department that specializes in a very narrow band of legal issues and usually hands it over to the appraisers after the fact. I think a group of specialists that handle intangibles would be highly valuable, because to try and train your entire state of assessor appraisers in the area of intangibles, when it in fact is not a static but moving kind of target based on property by property and the changes that seem to be flowing from the courts legally, it might bode well to, specify a group that handles those. And then, within that group, you could break it down to apartments, I'm sorry, hotels, fast foods, car washes, restaurants, whatever grouping seems logical and beneficial, because that way people can stay in their lane and be specialists rather than, being a jack of all trades and an ace of none. That's really my comment and suggestion, because I think in the long run, it would probably be more productive if not everyone worked on intangibles, but people that were really knowledgeable worked on them. Thank you.
Thank you. And we're going to go ahead and see if there's any other members of the public that would like to comment on the Zoom call. Seeing none, I'm going to go ahead and close public comment on agenda item number 3. And now, Assessor Torres, I do like to give, if you want to close out your side. And I really appreciate you bringing this whole team together. It's really insightful.
Certainly. I, again, just want to thank the members of the board here today for giving us the opportunity just to, again, lay this foundation of understanding, so we can have a comprehensive approach with a shared understanding of what our challenges are, the principles at play in our work, so that we can move through this methodically with a lot of thoughtfulness. I think that's what's going to be required to best engage in this issue and also address what the commentator made in terms of all the moving parts that are still in play right now that have an influence on, and may have an influence on how we do our work, and the level of specificity that is or is not provided in that flow of outcomes, and also in the various bodies, whether it's the courts, whether it's in our assessment appeals boards or in our day-to-day practice, just making sure that we're together seeing the same elements and coming to the same conclusions about what it is we're talking about that needs our attention today. We are here for you. We are here to engage in this process productively. And again, I want to thank everyone for making the time. Again, from Napa County, from Santa Barbara, from San Francisco, Los Angeles, and San Diego. It has been a joy to work with this group from across the state to begin this dialogue with you and to create the presentation that you've heard today. So thank you very, very much for the opportunity.
Thank you so much, Assessor Torres. The work product certainly speaks for itself. I believe now is a great time to break for lunch, everyone. We're gonna come back. We're gonna take an hour lunch, come back at about 1:25 and hear agenda item number 4. So take your break. There's a cafeteria across the street, and let's all reconvene here in about 1 hour at 1:25. We are on recess. Thank you.